Welcome back to 18 News at Noon, and welcome to this week's in-person segment of Law Talk, sponsored by the Law Office of Welch, Donlin, and Zarples. I'm joined this afternoon by attorney Anna Zarples. Thank you so much for coming out and joining me in person today.
Nice to be here.
It's the first time we've ever talked to you. We feel like we talk on Zoom all the time, so it's great to actually meet you in person and be sitting right here.
We're breathing the same air.
It's great. It's great. So I just want to transition now. Our active military members and veterans hold a very important place in our community, and especially with the VA and Bath and just our area, we understand that there's a law that's due to change. Active duty service members can now bring medical malpractice suits against military doctors, which is something that has been barred since the 1950s. So our first question, just can you explain what this change is and what it means for our service members?
Sure. So these types of claims, as you said, have been kind of barred since 1950, and in 2020 the National Defense Authorization Act was signed into law by President Trump, and it gave active duty military members the ability to sue military doctors. And when I say sue, that's actually not the proper term. They can file claims. They don't have a right to a civil lawsuit. They can bring claims within their own branch of their military. So if they're Navy, they can bring it to a Navy board. If they're Army, they can bring it to an Army board. But they don't actually have the same rights as a civilian does, but it's better than having no rights at all.
And what is the statute of limitation for service members?
Sure. So if a service member believes that he or she may have a claim, they have 2 years from the date of the negligence by the doctor to file that claim with their branch. And there is actually a special exception that was put into place in the law that actually made it retroactive for 2 years prior to the act being signed into law in 2020. But that's just a temporary thing. But going forward, it will be 2 years following the Federal Tort Claims Act statute of limitations, which is similar.
And if a service member is out watching this right now, what steps should they take? What does that initial process look like?
Well, as a lawyer, I always want to tell people to seek the advice of a lawyer, because individual facts and circumstances vary from claim to claim, but they do have to put together a submission for the Department of Defense. The Pentagon looks at that, and they determine, whether or not this is a claim that should be paid and how much it should be paid. Now, a service member can bring that claim by themselves, or they can have the assistance of a lawyer in filing that claim. And since these claims have not been made until recently, we don't really know how successful people are going to be. So it doesn't hurt to seek the advice of a lawyer to help you file that claim.
So we're just kind of we're working through it together at this point. We're learning everything a little bit as we go.
We are. Medical malpractice claims are very technical claims because they involve both legal and medical elements. So a lot of times, if you're alleging negligence against a doctor, you need to have some other expert or doctor say, yes, Dr. A screwed up and this is how he or she did it, A, B, C, D, and that's how successful claims are brought.
All right, Anna, well, thank you so much. We appreciate your time this afternoon, and if you have a topic that you would like on our next segment of Law Talk, you can email them to us, news@wetmtv.com. 18 News at Noon will be right back after the break.